before the Anti-Corruption Court, the Honorable Chief Magistrate, Mr. Ogoti, among the conditions that he had imposed for the admission of the governor to bail was that the governor should be barred from accessing his office in the county of Nairobi. Now, we have filed a constitutional petition to challenge the constitutionality of that order. If you have a chief magistrate ordering an elected governor to stay away from the entire county, that court has converted itself effectively into an election court. This is an elected governor, and yet Section 62, subsection 6 of the Anti-Corruption and Economic Crimes Act says that where there is a procedure of removal, as in this instance in Article 181 and Article 182 of the Constitution, which provides for the removal and for the vacating of the governor from office, the stepping aside procedure for state and public officers that is prescribed in Section 62, subsection 1, subsection 2, subsection 3, subsection 4 of the Anti-Corruption and Economic Crimes Act does not apply. So we have gone to the Constitutional Court to say that Article 27(1) of the Constitution provides the protection of the law to everyone, and everybody who invokes the law must then be afforded the protection of that law. So there is no way an anti-corruption court sitting in the chief magistrate's capacity can, as it were, order the vacating from office of a sitting elected governor. So let's be clear. We are not saying that the anti-corruption court has no power to order for the arrest or the charging or the process of the trial of a sitting governor for alleged offenses under the Economic Crimes Act. No, that's not what we're saying. What we are saying is you cannot declare the entire county as a scene of crime. That is even a practical impossibility. I do not even know how we can describe the entire county as such. So we are saying, pursuant to the constitutional provision of the principle of rule of law under Article 10, sub-Article 2B of our Constitution, then the governor is entitled to a description that fits within the practical realities of the 17 sub-counties of what constitutes the crime of sin in this particular case. Remember, not a penny has been ascribed to have moved from the county coffers to him in these alleged offenses. So in the Constitutional Court, we are saying these allegations, if then they translate to a governor sitting elected, duly confirmed in office, to vacate office, then we are, as it were, undoing our constitutional structures of governance. And then where do we stop? If today we are saying a sitting governor is, by mere allegation of having an alleged anti-corruption and economic crimes proceeding before a court of law, has to step aside, and an assumed takeover by the sitting governor, what stops the political mandarins who are bent on the sabotage of our constitutional order then initiating a similar criminal process against that deputy governor? And the cycle goes on and on and on and on. Is this the intention that we had when we framed our constitution? Any particular Article 181 and 182 of our constitution, which then say this is how you remove a sitting governor, and this is how a sitting governor vacates office. So we are saying in the Constitutional Court that a criminal indictment, a criminal charge is not one of the grounds for the removal or the declaration of the vacancy of the office of a governor.
Any directions?
We are also seeking that all the 3 judges in this division recuse themselves. They have pronounced themselves in respect of these provisions of the law. They have declared that these sitting governors, the Honorable Moses Kasaine, should move away from office, which is, as it were, a constructive vacating from office, a constructive removal without due process. And they haven't been found guilty, and B, the Honorable Waitizo for the Kiambu County. I do not agree with any allegations leveled against them constituting a ground for them to vacate office. I agree with the criminal process going to full trial, and it becomes a full-blown trial, so that then we are able to decipher on what basis has a decision, a verdict, fully tried and subjected to the test of the law, has been arrived at. But we cannot, by the mere indictment, by the mere arraignment of a sitting governor in court, say they should vacate office. That, my fellow Kenyans, is an unconstitutional path and a dangerous one, where we will teeter on the precipice of a misgovernance that we should not allow or permit. And let us remind those in power, His Excellency the President of this country and his deputy, who are facing criminal indictments, far much more worse, at The Hague. And no one asked them to step aside because of what? The same constitution protected their presumption of innocence. Let us not apply double standards when the political situation so suits us. Let us be people of virtue, and let us be people who are bound by the principles that we have enshrined in Article 10 of our Constitution. And let us not say, for His Excellency the President of this country, when he's facing criminal indictments at The Hague of rape, of murder, of displacement of population, they are entitled to continue in office, they are entitled to go on in office. But when a sitting governor then faces an indictment, an allegation, without proof, at the point of indictment, that they should step aside.
Thank you.